presented all the views which I express in respect of all the issue, both the motion for leave to adduce or produce fresh or additional evidence and the main appeal itself. But I would like to say that the point raised by the Learned Senior Counsel for the appellant, Chief Chris Uche, particularly in respect of the application of Section 285(6) of the Constitution, appears to me interesting, attractive. But when Electoral Act 2022 is with respect to Chief Uche spacious, as demonstrated in the lead judgment, the provisions of Section 285(6), even if the Court of Appeal is not specifically mentioned in that section, the provisions of Section 285(6) is applicable and apply to all proceedings in respect of all petitions, whether before tribunals or the Court of Appeal sitting as a court of first instance trying a petition named Presidential Election Petition, for which it was conferred or vested with the original exclusive jurisdiction to try and entertain under Section 239(1)(a) of the Constitution, not elevated to a higher pedestal than any of the states of the Federation. It is for the purposes of the presidential election, one of the states for which a candidate is required to obtain at least 1/4 of the votes in 2/3 of each of the states. So I totally agree with the lead judgment that this court lacks the requisite jurisdiction to entertain the application for leave to produce fresh or additional evidence, and that this appeal is also and deserves to be dismissed. I also dismiss the appeal, and that will be my judgment in this appeal. I abide by the consequential orders made in the lead judgment on cost to be borne by the parties for the prosecution of this appeal.
My little brother, Salawa, will deliver his judgment.
My learned brother, the Honorable Justice Okoro Jesse, has accorded me the opportunity of a preview of the judgment that he has just delivered. I must say that I have read that judgment, and I'm very much content and appreciative of the far-reaching, erudite, reasoning and the conclusion that have so far been reached in the lead judgment. I concur with the highest sense of responsibility with the reasoning and conclusion reached therein. With particular regard to the interlocutory application, thereby urging upon this court to grant leave to the appellants to procure and transmit and adduce fresh or additional evidence at this crucial point in time of the appeal. I concur most assiduously with the conclusion that has been reached in the judgment of my learned brother that such an application is grossly unmeritorious, thus ought to be dismissed, and same is accordingly hereby dismissed by me. And as for the substantive appeal itself, which has been predicated upon a total of 7 issues, I agree entirely with the reasoning eruditely expressed by my learned brother that each of the 7 issues that have been canvassed and argued by the appellant are grossly unmeritorious, thus ought to be resolved against them. Without much ado, I hereby accordingly dismiss the appeal for being grossly unmeritorious. As usual, it is not the time for us to read elaborative judgments. Just like my learned brother has said, 12 hours. We're not going to do that because learned counsel.
My Lord Jaro, read to it.
For granting me the privilege to read in draft the lucid and illuminating leading judgment just delivered in this appeal. I start with the application. The application seeking to adduce additional evidence or fresh evidence, I also find it lacking in merit. The application is frivolous and vexatious. It deserves to be dismissed, and it is hereby dismissed. Now, coming to the substantive update in the substantive appeal, it is also dismissed. On the whole, therefore, the appeal is dismissed and the judgment of the lower court is affirmed. Parties in this appeal shall bear the...
With the kind permission of the learned presiding justice, let me also express my view. I had a preview of the judgment delivered by my learned brother, Lord Justice. The seal of the Embassy, High Commissioner Consulate. Such authentication is an assurance of the origin and authenticity of the foreign disposition. In our present case, the certified shorthand reporter, before whom the deposition was made, did not authenticate the deposition with her seal. She merely signed a certificate of reporter bearing her name and number, page 126 of Exhibit C. Being a deposition from another country, it cannot be used in Nigeria without authentication. The authentication of the oath administration is mandatory. I have wondered why the deposition said to be made pursuant to the 3rd October 2023 order of the United States District Court for the Northern District of Illinois in case number 23 CV 05099 for use in a foreign country was not made before the court in the said proceedings. And if made elsewhere in the law office of the first appellant's attorney, why was it not filed in the above-mentioned court because of the peculiar circumstances of this case and adopted as a deposition ordered to be made by the court so that it can form part of the record of that court to enable the court issue it as part of its record, and so authenticate it with the seal of the court. The deposition is headed in the United States District Court for the Northern District of Illinois in reapplication of Atiku for an order directing discovery from Chicago State University pursuant to U.S.C. 1782 number 28 CV 05099. This gives the impression it is a process of the district court or that the deposition, though made outside the precincts of that court in a private law office, is part of the proceedings in case number 23 CV 05099. If it is indeed a process of the said district court, or forms part of the proceedings in case number 23 CV 05099 before it, then it ought to have been authenticated by the official seal of the court and the signature of the relevant officer certifying it as a true copy of the part of the record of the court in case number 23 CV 05099. Without such authentication, a deposition cannot be used in the Nigerian court as part of the proceedings or in the said U.S. District Court. And I've continued to wonder why the appellant did not use the advantage of the order of the district court that the college produced documents and a deposition concerning those certificates. Why they didn't use that advantage to secure a letter from the college under its letterhead, seal, and signature, disclaiming the certificate presented by the second respondent to INEC as not one issued by the college. That was not done. Instead, they resorted to this deposition, which has no features of authentication, thereby rendering it spurious and inadmissible. I agree with the able manner the lead judgment has dealt with it. I agree totally with all the reasons given in that decision as to why such an application should be refused, and it emphasizes one point. It was obvious to all, including those who brought it, that it was going nowhere. Then the question is, why was it brought? The issues raised. Let me also join my Lord Garba to talk about a question of Abuja and 1/4 of the votes there, that the candidate must win. They view that the provision of the Constitution should be applied in such a way that the votes in Abuja